So we're looking at the War Powers and Military Jurisdiction, JAGS text number 4. And the reason why we look at this is because the Constitution the Constitution of the United States is a military constitution, at least for all of Article 1 and part of Article 2 and some of Article 3. So we're looking at page 15, military tribunals, and there's just a few things that I want to point out in here. Jurisdiction as to persons. Generally, the Articles of War apply to those who can be considered part of the Army's personnel. In times of peace, when the Army is abroad, outside the territorial jurisdiction of the United States, they apply as well to all camp retainers, so military post and the seat of government, and other persons accompanying or serving with the Army. So there are people who are civilians who are what we call appropriated personnel, and I've explained that in another video. I'll explain it again later. Appropriated personnel who are essential to the mission of the military, and when they are working for the military, they are sort of in a quasi military jurisdiction. Now they go home at night. They're not under the military jurisdiction anymore unless they're an essential personnel, in which time they can be called in. But let's not talk too much about that right now. We'll get to that on another video in this podcast. In time of war, this latter class, the civilians working with the military, is subject to the articles whenever with the Army in the field, within or without the country. So if it's saying when civilians, and if you're not in the military, you're a civilian, are subject to the laws of the United States, which makes the laws for the military only, if they're subject to the laws of the United States only when they're with the military, then that means they're not subject to the laws of the United States when they're not with the military. The authority of Congress to make such civilians subject to military law is implied from the broad war powers set forth in the Constitution. There is no violation of the guarantee of the Fifth Amendment, inasmuch as that amendment itself accepts cases arising in the land and naval forces. It has been held that the meaning of the phrase persons accompanying or serving with the Army, which is used in Article 2, covers cases of those present with the military commander's permission. It's also been ruled that war correspondents, members of the Red Cross, YMCA workers, civilian members of a crew of a United States Army transport anchored in a foreign harbor, civilian employees of a contractor at a leased base in a British possession, are persons serving with the armies in the field and are subject to trial by court-martial. Civilian internees and prisoners of war are by virtue of the Hague Convention subject to the Articles of War and trial by court-martial. Okay, so we have basically here 3 different types of people. Those who are civilians getting paid to work with the military, and then we have some people who show up at the commander's permission and are with the military, and if they violate if they're a spy or something, they're subject to the court-martial, the military laws, and civilian internees and prisoners of war. Okay, so if you have to meet these requirements to be subject to federal law, then if you don't meet these requirements, you're not subject to federal law, whether military time or peacetime. Now, this is specifically talking about wartime and certain situations. So if there's certain situations where some people meet the requirement for being under federal law or military law, then there are requirements that have to be met even in peacetime, or there are people who don't meet the requirements, who are not under federal law, who are not subject to military law, whether in wartime or peacetime.